Hi, this is Julie, and this is part two on our video podcast about basic considerations in drafting California legislation. Continuing with our exploration of drafting of bills in California, let's look at some of the considerations that we need to take into account when working on bills and amendments. Now, we should generally begin drafting by keeping at the forefront of our minds the desire to fulfill the plain meaning rule. This means that your bill drafting needs to use simple language rather than technical or legal jargon, and it should be limited to simplistic language, except where reasonably necessary to change it. We want to try and use ordinary language that's generally known and understood by the average person. The language we use should be clear and brief and limit any unnecessary, confusing, or redundant words. Also, you need to think about when and where it's appropriate to define terms used in your bill draft. While sometimes it's necessary or desirable to be vague, we want to try and avoid that as much as possible. We also need to recognize the proper use of terminology. What's the difference between the terms means and includes, for example? According to the U.S. House of Representatives Office of Legislative Counsel, the term means is exclusive, while the term includes is not. For example, if the statute says the term X means Y, then it can't mean anything else. On the other hand, if the statute says the term X includes Y, then it could include something else. How about the difference between shall and may? Again, turning to the U.S. House of Representatives Office of Legislative Counsel, the term shall means that it requires an action. The term may means it's a permissible action as specified, but it's not required. On the other hand, may not is also mandatory in some jurisdictions and is often used for denying a right or a power. In general, bill drafters need to use a singular word rather than the plural form because sometimes ambiguity is created when the plural version of a word is used. For example, the U.S. House of Representatives, again, Office of Legislative Counsel, uses the example of drivers may not run a red light versus a driver may not run a red light. In the first instance, one interpretation is that a violation would only occur if two or more drivers ran a red light. That ambiguity is eliminated if the singular version of the term driver is used instead of the plural term drivers. Another example is understanding the difference between some similar words and which one is appropriate for your bill, such as assure with an A, which means to create confidence, insure with an E, which means to make certain, and insure with an I, which means to provide insurance. In California, we have a number of substantive drafting principles which we should remind ourselves of. For example, the single subject rule. A bill cannot deal with multiple subjects not expressed in its title. Germaneness is an amendment drafted for a bill germane to the current contents of the bill. Urgency clause, remember statutes take effect immediately, but they require specified language. General versus special statutes. In some instances, a special statute may be required due to unique circumstances. There's also special rules on tax measures, for example. What's a tax levy? What is the vote threshold needed? The Constitution, both at the federal and state levels, provide consideration that we need to do. So in putting pen to paper and beginning to draft, the bill drafter needs, again, to think immediately about the goal or the intent of the proposed legislation. And based upon the feedback that the drafter's gotten, as well as any materials from the author's office or the supporters, You may have to conduct some additional research to examine, for example, are there similar statutes in current law in your state? Are there statutes at the federal level or in other states that might be able to be utilized as a basis for your draft? It may also be necessary to conduct research on the particular issue being addressed in order to better understand how such a law might operate. Once you complete your review of current law, you've researched it and gotten the information from the bill's author or supporters. It's time to put pen to paper and begin writing an initial draft of the bill. Now, based upon where to place the bill in existing law, that's also a key thing. For example, which of the 29 codes, which division or chapter, what statutory scheme are you going to add this new language to or amend in? Are there already terms that are defined that you can utilize? Now, after you've completed your initial draft of a bill, it's always a good approach, if possible, to set it aside for a few hours and even a few days if possible, assuming you have sufficient time to take a break from it. And then when you revisit that draft, it's best to try and poke some holes in the language. Did you properly define or cross-reference all the necessary terms? Are there any ambiguities in the language that you drafted? Have you taken into account the general rules of statutory interpretation or construction that courts will utilize if they ultimately have to review your statute that you're drafting? Those are some of the issues that you should address and questions you should raise when you look over your initial draft before finalizing your bill.